kind of believe, as I look around, I think everybody is present. Attorney Tom Carrick, who is standing in for Matt Cook, is not getting on the Zoom. He's given to me his cell phone number for when that might be needed. So as I look around, and I encourage everybody else to do similarly, I think the group has assembled. I've got Billy Ray, and then I've got Marlon, Mr. Pritchard, Libby, and Mr. Froge as the board members. I've got Rick Hughes on behalf of Libby. I've got Chris Davenport on behalf of Billy Ray. I've got Ron Hampton. Matt, you're on behalf of the board as well.
Should be Matt Baker.
Matt Baker, you're muted. Could you unmute?
So I have to tell him to call him, I guess.
Yeah, Matt, can you unmute your microphone, please? You're trying? Okay.
There you go.
There we go.
Right. So you're here on behalf of the board or someone individually?
The board, sir?
Okay. So you're here with Mr. Hampton on behalf of the board?
Yes, sir.
Okay. And then Mr. Gardner's here as counsel for Mr. Froge. So I think everybody is here. I will leave it up to board counsel as to how you commence the meeting. My thought is we would all sit here together as you do it, if you would, if that's agreeable with you, or else I can take the board members and counsel for the board into a separate meeting room.
I don't think that's necessary. We can have the start of the meeting.
Okay.
And then we'll go into session.
Okay. All right.
I agree.
All right.
So DT,
Okay.
I guess if we got to give Josh and them a heads up so they can get us online there.
Okay, go ahead. Put us online. Are we?
We're waiting to report back from.
Cody, are we online yet?
Okay. DT, you should be good to call the meeting to order.
This is a special session of the Glasgow Electric Plant Board called together for the purpose of a mediation. That's the only item on the agenda. Do I hear a motion to approve the agenda?
Motion.
Motion is made. Second? Second on the motion?
Second.
Have a second. All in favor? Aye.
Aye.
Aye. Okay, the first item on the agenda is to call for an executive session. And with that, we will go into an executive session.
Wait, DT, somebody needs to make that motion
Right.
and make it such that it's basically what your agenda says. We need to identify the KRS, which is in the agenda. The purpose of the why we're going into executive session, not just a statute site. So I think if you just somebody would make the motion consistent with what it says on the agenda, that would be sufficient. And then a second, and then a vote.
Do I hear a motion?
I make a motion that we go into executive session under KRS 68.8101 subsection C for the purpose of court-ordered mediation.
Have a second?
I second it.
All in favor, say aye.
Aye.
Aye. Motion carries. We will go into executive session.
All right, so I guess, Josh, whatever you got, or Cody, whatever you got to do now to put us in executive session. And then, Mr. Walter, I guess it'd be turned over to you at that point.
Cody, you just have to turn it off. We are out of executive session and we have come to an agreement. Ron?
Yeah, at this time, members, I think based upon the mediation now being concluded, we would need to take action out in the open meeting. So we would need a motion to approve any terms of the mediation that the board is going to approve. And with that, we have asked the mediator, Mr. Walter, to recite those terms. And upon reciting those terms, we'll make sure that everything has been included by asking. I think he's going to have everything by asking other counsel just to be sure, because there's quite a few terms here. And then once we hear those terms, we should ask one of the board members to file a motion to approve that, second that, and then vote on it.
Okay. Thank you, Mr. Hampton. And thank you, Chairman Froge. As part of the settlement terms today, the following have been agreed upon during the mediation, subject, of course, to resolution by the board. The terms, as I understand them, are as follows. Effective March 1st, 2021, Billy Ray will announce his retirement, or will be retired. He may announce his retirement at any point between now and then. After March 1, Billy Ray has agreed to act as a consultant advisor to the Electric Plant Board for a minimum of 3 months. At his option and his option only, he may continue thereafter for an additional 3 months or no more than 6 months total. During that period of time, Billy Ray will be entitled to receive his full pay and benefits for so long as he is acting as an advisor consultant to the Electric Plant Board. In addition, Billy Ray, for his severance from his position with the Electric Plant Board, shall receive a lump sum payment of $250,000 on or about June 1, 2021, which is the conclusion of the initial 3-month period of time that he acts as an advisor and consultant to the Electric Plant Board. The parties contemplate that a mutual release will be prepared, and Attorney Matt Baker is charged with the initial drafting of that document, subject to approval by all other counsel for all other parties. Included in that mutual release will be a mutual non-disparagement provision wherein no one will offer any disparaging remarks either against Billy Ray or against any member of the current board of directors. All members will be expected to sign that individually. All members of the board of directors, will be expected to sign that individually, as well as Billy Ray individually. Billy Ray will be allowed through an agreed order to intervene in the Barron Circuit Court action for purposes of preparing all documents necessary for the enforcement of this settlement agreement, including the fact that an agreed order of dismissal with prejudice will be prepared and will be circulated and signed by all parties, and then held in trust by Attorney Chris Davenport until such time as the $250,000 lump sum payment has been made, at which time that agreed order of dismissal will be filed with the Barron Circuit Court. Two other matters that have been agreed upon, Matt Baker, on behalf of his clients, have prepared and filed a writ of mandamus with the Kentucky Court of Appeals. He will withdraw that immediately so that there is no further action needed in the Court of Appeals. Matt can probably be granted 24 hours, although that time period wasn't discussed, to get a motion to withdraw filed with the court. In addition, following the initial mediation I conducted in October, there were motions for contempt filed with the Barron Circuit Court. As possible sanctions, the court indicated there was consideration for attorney's fees and other charges, but each party will notify the court that they are withdrawing any request they may have for contempt sanctions. And Mr. Chairman and counsel for the board, I think those are the terms that I had recited in executive session. Hopefully I have not omitted any, but we've got several sets of ears around the table that can tell me if I have.
I believe you've included them all, Mr. Walter, but I'm certainly open to if anybody's got any other comments before we make a motion.
Rick, I have a couple points, and I may have missed these, so don't be offended if I just missed, but I'm not sure I heard, or I would like to clarify that the plant board itself is likewise a party to the mutual non-disparagement, mutual release that Mr. Baker is to prepare along with the individuals you mentioned. And then secondarily, that the parties will be agreeing to an agreed order which allows Mr. Ray's intervention in the pending circuit case for the purposes of the settlement agreement and getting these things done.
Okay. Thank you for bringing those up, Chris. I know, or I believe I stated that there would be an agreement allowing Billy Ray to intervene in the Barron Circuit Court action for all purposes, especially relative to the settlement. I did not mention that the mutual release would include the electric plant board as a signator, with Mr. Froge as its chairperson being the person who would execute that. But the electric plant board is a party to the mutual release and mutual non-disparagement provisions. Anyone else? Okay, Mr. Hampton's back to you and Mr. Froge.
All right, Mr. DT, what we need, then we will need a motion to approve those terms as recited by Mr. Walter and clarified by Mr. Davenport. We could get a motion and then a second, and then we'll be, I don't know that there needs to be any further discussion. So it'd be up to you guys, but I wouldn't think so since we just included the
Mr. Froge, you're muted.
Yeah.
There you are.
Do I have a motion?
I'll make that motion.
Motion's been made. We have a second?
I'll second it.
Have a second. Any further discussions? Hearing none. All of the voting members would signify by holding up their hand. Yes.
Yeah, why don't you take a roll call vote, DT?
Okay. Roll call vote. Debbie?
Yes.
Marlon?
Yes.
Glenn?
Yes.
DT votes yes. Motion carries.
Next order of business is just, I guess, the motion to adjourn unless Mr. Walter needs anything further from us.
Thank you for the opportunity, Ron, but no, I need nothing further. I thank all of you for allowing me the opportunity to fix what I didn't take care of the first time.
Motion to adjourn?
Wait a minute. Rick, we certainly appreciate you and the hard work that you put into this mediation. It's been a little unorthodox maybe, but we certainly appreciate you very much and your patience and your insight. So now, DT, I will happily make that motion for us to adjourn today's meeting, and I'll see you guys tomorrow.
Right. Second? Have a second on that motion to adjourn?
Second on. I'll second.
All in favor by signing off.
Good day.
Good day.